I will be interviewing Maria Hauser, counsel at the Secretariat of the ICC, and our topic concerns how the ICC arbitral process works in practice. The idea of our around 50 minutes interview is to give you an insight how arbitration at the ICC works inside the box, and now for those of you that are not so familiar with it, and to demonstrate also to you some of the main benefits that and now we think ICC arbitration has. We try to do this by providing you with several practical scenarios that we see as typically arising in international arbitration proceedings. But before we get to this, I think it would be interesting maybe for some in the audience that you tell us a little bit more about the role of the ICC's court as compared to the Secretariat as such, just the court itself.
So the court, hello, it's my first time in Helsinki, so I'm very excited, and it's too bad that I'm only staying so short. But anyway, so the court is a body composed of practitioners. I think that will be the opening point. The court, headed by Alexi Moore, is composed of people of over 100 members all over the world who are appointed by the governing, by the World Council, by the local communities. And so each local community, each country sends its representative to sit at the ICC court. So you will have understood that the court members are practitioners, lawyers, professors, arbitrators from given jurisdictions who come to Paris or by video, help the court taking important procedural decisions. Mm-hmm. And there are also 17 vice presidents who help Alexi in doing the job. So I would say the court is a body of practitioners who help us do the administration.
So how many Finnish court members do we have?
Well, there's Carita.
Carita and?
I think it's only Carita for Finland, no?
One. Yeah, but it's really a truly international body. So and all the court sessions are a great experience. But another thing which would interest me, what is the number of cases the ICC is dealing with over this long tradition of years, I think?
I think more than 20,000 cases in
all
total.
Over. Okay.
Now we are approaching 30. We are already doing cases 20,000 something, 22, 23,000 numbers are 23,000 or something. So, yeah, in total, from the beginning, from 23,
and each year?
23.
Each year?
And each year, last year I think we had nearly 900 cases, new cases, I mean.
Okay, and now this sounds much.
Yeah.
And so, what kind of personnel is assisting or helping to administer these cases?
So obviously, these are not the court members that are in touch with the parties. Yeah. And the system that we have put in place, like in any other institutions, there is a secretariat being the platform between the bridge between the parties and the court. Mm-hmm. So the court, in fulfilling its functions, is assisted by the secretariat that is composed of about more than 80 people, mm-hmm. Who are lawyers and assistants and finance people, sort of professional support staff. We are essentially the main, the people that you know are case management teams. There are 7 case management teams in Paris and 1 in Hong Kong and 1 in New York. There will be additional, as you know. And so there are case management teams that simply handle the cases, and when parties write to the ICC, they write to us, Secretariat.
And how do you then interact with the court members? So how to bring everything together?
Right, so then whenever court's decisions are not always needed. Sometimes under the rules, certain decisions are taken by the Secretary General, for instance, of the so the boss of the Secretariat. But when the court needs to take a decision, for instance, and we may be talking about it later, to approve an award, the Secretariat simply prepares a report. Mm-hmm. So whatever the parties feed to us, whatever comments the parties give us, or whatever the tribunal asks us to do, we will prepare a report, take into account the court's practice, precedents, in order for the court to take an informed decision on a given case. So the court decides based on Secretariat's reports.
But 100 members from all over the globe are part of the court. How does such court sessions look like? How often do the court members meet? Do they meet in person? Do they meet via telephone conference? Is it about 100 people, or is it a limited number of persons?
No, the court sessions, so there are once a week, there are 2 weekly sessions. There's one session in the morning and in the afternoon, and each session is presided by president or one of the vice presidents, and 2 other court members sit. So court usually takes decisions through a committee session that is composed of 3 court members. Now, of course, there are also some particularly sensitive cases, such as the cases involving states, state entities, challenges, requests, and so forth. And these sensitive cases will be submitted to the plenary session taking place once a month. But then again, I mean, 100 people will not come to Paris for the plenary. Usually have around 40 people coming to Paris. But also sometimes for the past years, more and more people have participated by video or sometimes by telephone. So yes, we do allow so that not everybody has to actually come to Paris. More and more court members from other regions participate by video, I think, which is good for us in order to have a better diversity at the court level.
Thank you. We now hope that you have an idea of how the ICC court looks like and how it works together with the Secretariat. So we now want to take you step by step through the major aspects of ICC proceedings and its main particularities, so to say. So let us go to scenario 1, commencement of a proceeding. Let's imagine we have a Polish claimant. You are Polish, we call it Polsoft. And we have a German respondent, because I'm German, Deutsch mein, whatever. And Polsoft files a request for arbitration with the ICC. What happens then?
Well, the first question also that you can ask, does it have to actually submit it by a registered mail, formal notification? No, the first move will be to send it simply by email to the ICC, a request for arbitration, followed by hard copies, pay the filing fee, and then as soon as we have everything, it is the ICC, the administrator, that will notify the request to the respondent. And in doing so, it's not just that we just send it out and say, just, respondent, this is the request, do whatever you have to do. When notifying the request, we do provide some guidance to the parties, saying that, we are notifying the request today. We specifically invite the parties' comments on certain things. So it's not just we are sitting in the back. We try to provide certain guidance to help the parties efficiently across the first stage of arbitration. So we notify to respondent, and then we await respondent's answer to the request.
Okay, let's take the second scenario. I'm a difficult respondent, and I refuse to participate and raise objection that the ICC administers a case. What will happen then?
There is, as many of you know, there is a very thorough process when objections are raised. It does not block the proceedings. We have a very formal procedure that makes sure that when these objections are raised, they will be screened by the ICC. There is a process of team, then Secretary General making the first check. And if everything looks fine, so if the objections seem unfounded on a prima facie level, it seems like there is basis for the parties being bound by arbitration agreement. These objections will be just sent to the arbitral tribunal once.
So it's actually the tribunal that makes a decision on your
precisely. It's only in extreme cases, if non-signatories, and especially it happens in construction cases, sometimes main contractors want to bring in non-signatory subcontractors, people from different phases of the project, which may not always be ideal. So for these cases where people who have nothing to do with the dispute were brought in, there is a mechanism that would allow the ICC court, the administrator, to kick them out, essentially. Of course, without prejudice, there can be a new request for arbitration against them. But this procedure of screening jurisdictional issues it's essentially the principle is it goes to the tribunal, again, efficiency. We don't want to prolong this internal procedure, and only in extreme cases we can kick out a party, for instance, or claims.
Okay, so let's go to the next scenario and assume there is an ICC arbitration clause, but the place of arbitration has not been fixed. In a setting like ours, Polish claimant, German respondent, ICC arbitration, what would happen then?
We, of course, have to fix it in Finland, don't we? Well, the principle is that first, like an arbitration process, we have to hear the parties. So, of course, we are not tribunal, we are just the administrator, but we will first, prior to taking the decision on the place of arbitration, we will invite the parties' comments. And it may happen that the parties actually agree. They don't have to necessarily agree on the arbitration clause. They may simply subsequently agree. I know that personally I encourage the parties to discuss the issue between themselves, because sometimes if the administrator is very formal, it may discourage them from reaching an agreement, but sometimes I tell them, I invite the parties to inform the Secretariat by whatever date whether they have reached agreement on the place. And actually sometimes if you get the parties to talk, it may be more efficient than us. But so first we hear the parties, and then only if they disagree, the ICC court, so usually the weekly session, the three-member committee session, will be invited to fix the place of arbitration based on whatever the arbitration clause provides, on the parties' nationalities, on the, whether it's a neutral seat, convenient to everybody, safe in terms of enforceability of the award, friendly jurisdiction, and this decision will be notified to the parties.
And beyond this jurisdictional questions and a place of arbitration, which we all know is of high also legal significance, what are other procedural matters that the ICC court regularly deals with? Well, I would say the important role is with respect to the constitution of the tribunal. Definitely, well, we all know how constitution of the tribunal may be relevant for the enforceability of the award. That is definitely something that that is important to what we do. But also, and this concerns first often questions of how many arbitrators. Alexei has just referred to expedited provisions for small cases. The question will usually not arise, and if the case is small, expedited provisions, it will be one arbitrator. But in certain cases, the court has to decide on the number of arbitrators. The case may be, $3 million, but it may have some political sensitivity, and the parties didn't disagree, and so the court may need to fix the number of arbitrators. So fixing number of arbitrators and then deciding on the constitution of the tribunal. I think we may talk about confirmation process, for instance. Yes, I think the appointment of arbitrators is so central for the whole arbitration that we should devote some time on this issue also under the ICC rule. So if we get to the next scenario and assume that Deutschmein, and I have failed to nominate an arbitrator, so I really try not to participate. And now what will happen then? Now, assuming we are not in the scenario of expedited provisions, and assuming so that the clause provides for 3 arbitrators, the procedure will be that the ICC court will appoint an arbitrator on your behalf. But obviously, before we do this, we would send reminders, make sure that you are granted an opportunity to nominate, because afterwards, if we do not send these reminders, you can argue that you were deprived of the right to nominate an arbitrator. So after several reminders, we would the court would appoint an arbitrator on your behalf. And we would do this usually going through from national committee. So we would usually turn to the German national committee, as the Deutschmein is German, and we would write to the national committee, dear national committee, please propose an arbitrator to be appointed on behalf of Deutschmein.
these are the details of the case, and they make a proposal.
So it's not the court, I just imagine the 100 people or a subsection of it, but it's the National Committee. What is the National Committee? Maybe you explain.
So ICC is the International Chamber of Commerce, is an organization of businessmen that has branches all over the world. So our headquarters are in Paris, but we are active all over the world. So ICC has its committees, like ambassadors, like here in Finland, all over the world. The idea is to be closer to business community. We travel a little bit, but business is not just about arbitration, thankfully. I mean, arbitration has to be close to business. So in order to be close to business, ICC has its branches, national committees all over the world. These national committees, know also arbitration community better than us, and their role is to propose new people as well, because we know only people who acted as arbitrators or as counsel in our cases, but there may be some new people. So the role of the National Committee is to propose an arbitrator who, however, will not automatically become an arbitrator. The proposal is submitted to the court, and it is the court who makes the appointment on behalf of the National Committee.
So if you look for a Finnish arbitrator, you would call in regular course on the Finnish National Committee. They would propose 1 or 2 or even 3 candidates, and then the court would finally make the appointment.
Precisely, yes. Usually one candidate, but often there is a discussion with the National Committee.
Yeah, how much detail goes into such discussions? Do you look for certain qualifications, age, gender? What are the criteria?
It's an objective discussion. I mean, I cannot say I want a woman who's 30 years old. I want somebody who has certain knowledge in a given sector, who speaks certain languages, who has some experience as counsel in ICC cases to at least know how the process looks like. So the wish list that we set is based on objective qualifications. Now, of course, there may be some cases which are more complex that we may additionally stress the need to have an experienced person or somebody who's experienced with state entities. But we base on objective grounds now, and of course national committees know the local community, and they may additionally take into account the subjective elements, such as,
But I would imagine that all over the globe you have strong national committees, which have databases, which closely cooperate with the local arbitrator scene, and others which do not provide for sophisticated proposals, or is it?
I mean, it's a work in progress, and certain national committees, of course, work less well than others, but I think it's also a work in progress between us and the national committees. I've seen many committees that have improved. For instance, my native Polish National Committee has now been very, very dynamic, and that's a work of people. So national committees, it's people who are in Finland and Poland and Germany. So they may improve. It's true that there are some national committees that work better than others, but...
and I'm sure the Finnish National Committee will work perfectly well, which is to the profit of everyone here, probably in the room. Are the arbitrators nominated by the parties? So I'm assuming I would finally decide to appoint an arbitrator or nominate an arbitrator. Are they ultimately becoming an arbitrator, or is there still another layer of scrutiny by the ICC court?
So no, they have to be confirmed by the ICC, and that is a mandatory procedure. There was a case in which actually, we haven't discussed it, but years ago I had a case where in the arbitration clause the parties wanted to exclude confirmation process. Well, that is not possible. That is a mandatory confirmation process. So if when you are nominated as an arbitrator by a party, we first invite you to file a statement of independence and partiality. Here again, it's not just, I had cases where an arbitrator who I knew had cases, for instance, with the same entity, files a clean statement of independence. And this is where the Secretariat, I think there's a next panel on the role of the Secretariat, We would call the arbitrator and say, well, hello, wouldn't you like to disclose this and this and this? So the disclosure is the first, the acceptance and disclosure is the first stage. And then the arbitrator will be confirmed by the court. In less problematic cases where there is disclosure and there are no objections, or if there is no disclosure of conflicts by the arbitrator, the confirmation may be simply deferred to the Secretary General. So it will be soon Alex Vesas, currently Andrea Carvalharis, who may, in simple cases, confirm the arbitrator. But this confirmation is necessary for the arbitrator to actually take the function.
And if the other party objects, what would happen then?
The court, so the committee, the weekly committee session, will have to decide on the objections based on the report prepared by the Secretariat. So the parties' comments will be presented to the court. We will also present to the court's precedents, how in similar situations, each situation is always different, but in similar cases, how the court decided based on what elements, and then it is for the court to decide whether to confirm or not. So the mere fact if an arbitrator makes a disclosure and the objections, this in and of itself doesn't mean that the arbitrator will not be confirmed. The court has an independent, makes an assessment whether the disclosure is so severe that the arbitrator should not be confirmed.
And we have learned today that under the new notes, there is really an extensive disclosure obligation, so the ethical standards are truly high. Do you put the arbitrators on alert that these new standards apply?
Yes.
Because my impression is that even arbitrators who arbitrate quite often do not read the note and are not aware. Are they put on alert?
Well, I know that I do, and it's a work in progress as well in terms of disclosure standards. In certain regions, disclosure standards are different than in others. And it's also the fact that it is now on the note, it makes it easier for us. It's transparent. The note is very transparent, so it's easier for me to refer to the ICC note than to IBA guidelines. So the fact that the rules are set transparently in the note, that makes it easier for me to alert arbitrators, which I indeed do to the extent that I know of an existing contact with a party or prior engagements for the party. Yeah. This does not, of course, mean that we do the conflict check. The rule is obviously on the arbitrator to do the conflict check. It is not for us to do this.
In my interview script, I had as a next item and scenario advances on cost, and the scenario that I'm the difficult respondent, fail to pay my advance on costs. I just saw that we have another panel exclusively devoted to costs, so I wonder whether I should skip my questions, but maybe we can just briefly discuss it. For me, the cost things sound like a very complex scenario. How much time in the Secretariat is spent by administering the funds, which are often significant of an arbitration? How much does this involve in expertise and doing?
Usually it goes well. Usually the costs at the ICC, the cost system is pretty straightforward. Costs, and we are talking about ICC costs, are those that arbitrators' fees and expenses and administrative expenses. These costs are based on scales. So simply the advances that we ask are based on the amount in disputes, are fixed. The costs are fixed by reference to the scales. And then we just have to monitor and make sure that the parties pay in time. So it involves some time, but I would say that usually it goes well. Obviously, there are cases which are more complicated because the parties object and ask for reconsideration of the cost because, according to them, the case is more simple than the others. So these cases involve a little bit more involvement.
But imagine I'm a mean respondent. For example, you have claimed 2 million, and then I say, oh, now I counterclaim 200 million in order to make it really difficult for you. How do you act in this cases?
Well, if I were the claimant, I have several options. I mean, if I were a claimant, I would simply ask for to separate the advances on costs. And this process, the process is pretty simple, but it's true that people don't always understand it. So what happens often is people call the Secretariat to have some information about how this works, the process.
Yeah.
And then afterwards they make requests. But in your case, if there is a frivolous claim for 200 million, we will treat it as a simply claim for 200 million. It is not for us to consider whether it's frivolous or no. We will consider it for the purposes of the advance on costs. So if the
But you would make sure that the original claimant is not impaired by this tactic, so to say, so that he just bears the cost for his claim and respondent has to bear the major share of the costs for his counterclaim?
But we would, yes, and we would raise the possibility of separate advances in our letters or emails to the parties, but the request for separate advance has to come from one of the parties. So we will not automatically fix two advances.
But so in essence, the whole cost thing is not for the arbitrator to deal with, but it's dealt with by the Secretariat. Except
in administrative arbitration, yes, with the exception of VAT. That is, so we can just take deposits for VAT, but it's for arbitrators to handle VAT.
But I think the next panel will explain a lot, and if there are VAT questions, you become an expert after time, but it's really difficult. So let's just briefly mention another feature of ICC arbitration, the scenario of joinder. Just imagining I have a parent in a guarantee and you now want to claim against the parent company of Deutschmine. What happens under the rules and what is your function as a Secretariat or court in this regard?
So I think, like as Mika explained, we have joinder provisions that are similar, I understand, to the Finnish rules. Joinder is a possibility under the ICC rules. If you want to join the party, you just have to make a request for joinder. And if you comply with the formal requirements that are similar to the requirements for the request for arbitration,
so it looks almost
filing fee, it's fine. The party becomes a party. And then we go back to the, if the additional party, the joint party, has jurisdictional objections, we go back to the regular system of screening, ICC control exercised. But the joinder, I mean, I remember when the joinder provisions were put into the rules, people were commenting that there will be more joinders because the possibility of the joinder was put in place, that there will be so many joinders. It was not necessarily true. So in my region, for instance, it does not happen that often, joinders.
Yeah, I've seen a few so far. And are there any limitations concerning the timing of such joinder requests? Because I would imagine that this could also be used as some sort of a dilatory tactics to try in the course of the proceedings to get a third party in?
Yes. Well, under the ICC rules, the principle is that no additional party may be joined after constitution of the tribunal. Of course, you understand the reasons behind this, is that all parties have to be involved in the constitution of the tribunal. So the rule is that unless everybody agrees, including additional party, after constitution of the tribunal, it's too late to join a party. We set out deadlines, so we tell the parties, watch out, we will soon confirm the co-arbitrators. We remind you that this is the last moment for you to join a new party. So the Secretariat under the rules will set deadlines for making a joinder in this first stage of arbitration.
Okay, now in my mind, the arbitral process is progressing. We have a constituted arbitral tribunal. All procedural questions are solved. The parties file extensive submissions with numerous exhibits. The Secretariat is always copied in. It gets close to the hearing. What is the court's function or the Secretariat's services in this phase of the proceedings where the written submissions are filed and you get close to the hearing?
Yes, I think, well, in terms of process, because the role, I think it is the next panel that talks about the actual role of what we should do. But the process is that when the tribunal is put in place, we are sort of in a back seat. But you're right that we have to observe the process, sometimes intervene. I had a case, I mean, obviously it has not happened with people who are in a room, but, you know, for instance, a party requests interim measures and the tribunal announces that the tribunal will decide on them tomorrow without inviting the other side's comments. So typically, I would call the tribunal and say, well, maybe it would be good to invite the other side's comments. So we observe, but we check if everything goes fine.
So do I understand correctly that a member of the team in charge at the Secretariat is, upon receipt of a submission, as long as it is, will read the submission and mark procedural particularities that need to be dealt with, wait until the arbitrators react, and if not, intervene? Or how can I? Well,
intervene, I mean, that would be, I think would be too much. I think if it's extreme, we would intervene or just hint. Well, yes, we do take note of the whole procedure. We also have to regularly update the court on the advancement of the case. And in doing so, we have to provide the court with a detailed report as to what were the major procedural steps that took place. This will also, it's maybe discussed in a cost panel, the procedure and the efficiency of the tribunal will also be necessary when the court will be fixing the fees. So we have to monitor the whole procedure, because the way in which the tribunal conducts the procedure will be relevant also for the fixing of the arbitrator's fees. So this does not, of course, mean that we read in detail every submission. We just look through. We don't, I mean, that 200-page statement of claim, I simply do not have the time to read it, because I have about 165, 170 cases in my team.
Yes.
So I would not have the time to review it in detail. But you know, I have to have a look. I had a case where, at some stage, of the submissions, a party withdrew the claims, and then the arbitral tribunal. So I made a note about this in my file, and then the arbitrator awarded these claims in the final award. So had I not taken the note about the withdrawal of claims, there would be an ultra petita. So we observe, but we have to, yeah.
You observe, you record, as I understand, in your agendas of the case, so that it's all set out in writing and summarized in writing, the major steps of the proceedings, and if really necessary, you start to raise questions. And do you also work somehow as a soundboard for the arbitrators or counsel? I mean, how often does your telephone ring and someone wants to complain or ask questions?
Often, but I mean, again, this is the panel on the role. I personally encourage calls. As you know, in the beginning of the case, I sent an email to the tribunal. Well, hello, I'm Maria. I'm there to help you if you have questions. So quite often the arbitral tribunals call, but parties as well.
And I think it's a difficult scenario, in order to remain strict neutrality. So if just one party calls, it's maybe a very difficult issue.
Of course, we cannot provide advice.
Yeah.
So we cannot suggest anything to the party, but we can, under the rules, clarify how the rules operate. We can just explain, you know, refer to the excellent commentaries of the ICC rules and just explain what the rules say. Because sometimes, you know, the parties, especially in less regions where arbitration is not so developed, people simply don't understand. And the terms such as advance on costs, separate advances, joinder are not very clear. So our role is as well to provide some guidance in this during this process. Once I had a party who called me terrified, but Ms. Hauser, what is reference schedule? Really?
Yeah. So maybe Let's turn to one of the aspects which I find most interesting, and this is the scenario of a hearing has been taken place, a decision is about to be made. How does this work under the ICC rules? Do the arbitrators just write an award and serve it on the parties, or does it work completely differently under the ICC rules?
Yes, well, they have to submit the draft award to the ICC. Alexi has mentioned strict deadlines that we now expect the arbitrators to respect. So in terms of process, for instance, if a hearing took place and there are no post-hearing briefs, the team would usually, at least this is what I do in my team, write a little email to the tribunal. Well, hello, I hope the hearing went well. When can I expect the draft award? And then, if there are delays, we will follow up and regularly. So we will make sure that the tribunal informs the parties when the parties can expect the award. And once the draft award is ready, it has to be sent by simple email to the ICC team, the secretariat, the team in charge of the case. And the scrutiny begins. Yeah,
and scrutiny, I think it's a great word. And when I started with arbitrating matters, for me, ICC scrutiny was more or less a question mark, because I thought, what are they doing? And who is looking at what? What is scrutiny all about? So I think it might be interesting also for the audience to get a very practical understanding of what is done when an award gets into scrutiny.
Mm-hmm. So the moment I receive it, we mentioned that arbitrators have deadlines. It's very important that the team in charge also quickly does the scrutiny, because the arbitrators have done their work quickly. And so then I have to prepare quickly my report for the court in order for the award to be approved quickly. So the clock ticks for me as well. And that means that sometimes I have 4 or 5 awards on my table that I have to read in the same week, but that's how it works. And so the scrutiny is done by the most senior member of each team, so the counsel. And counsel usually have worked in private practice, so we are trying to do more legal work than just look at the formal aspects. Mm-hmm. I read the award in detail, and I look at the party submissions to make sure that the tribunals have not forgotten about some claims. Or if an argument is set out in the award that was not necessarily raised by the parties, I will take note of this, and I prepare a detailed report for the court. But before the court sits down at its committee session, looks at my report and the draft award, my report will be sent to the management of the secretariat, so at least one person. So it's either Secretary General or Deputy Secretary General or the Managing Counsel. At least one person will read the draft award and my report and may make additional comments or say, no, Maria, you're going too far. So it's a teamwork to finalize these comments. And then as soon as it's ready, the same week, the report with the draft award is sent to the 3 court members that will sits at a committee session.
But, sorry to ask again, but imagine I'm the arbitrator. I had this 1.5 year, very difficult proceedings. I now prepared a 100-page award. I'm super proud. I worked on it day and night, and now I hand it in. And now what exactly are you looking at? Is it the form of the award? Do you have specific checklists when looking at form things? Or is it the merit? I mean, are you rejudging what I thought came out from the taking of evidence? How far do you go when making your comments? What is it you are looking for? And then the next layer, and then the next layer.
The goal of the scrutiny of the review awards is to have an enforceable award. The problems with enforceability can be linked to small technical things, and we have to start with these small technical things, such as the names of the parties, the addresses of the parties, their representatives, the whatever else, you know, the issues of notification. So small technical things are important for enforceability. So we have established years ago a checklist, indeed, that helps us to complete this review.
And is it provided to the parties?
It is provided to the and to the arbitrators. It's available on our website. So, but in addition to the checklist, we have to think a little bit more, indeed, look in the reasoning. It's important that ICC awards, like many other awards, have to be properly reasoned. So we just have to look not only if all of the parties' arguments were considered, but also if the reasoning is convincing. Quite often it may be disappointing for the parties who have you know, spent a lot of money on expert opinions and have argued quantum issues.
If it's not addressed.
And then in the end, the tribunal says, well, I've looked into this carefully, and I decide to award 50%. And so I think the goal of the scrutiny is as well to have a persuasive reasoning in awards. And the sort of, you know, business, it's not just about enforceability of the award. I think the ICC court wants to have awards that are convincing to the losing party who has to pay. So in order to make such comments and make sure that the award is convincing, we have to understand a little bit the business aspect of the award. So I would say that I personally go quite far in the review of the award. But still, of course, you mentioned we don't impose on the solution. So our role is not to say whether the arbitral tribunal is right or wrong, although it does happen that as a result of the scrutiny, the questions that are asked by the court lead the tribunal to a different decision. For instance, that they change the fact that they have to provide reasons changes the decision, so that happens. But that is not our role. Our role is just to make sure that the award is properly reasoned and is whole of the necessary elements. It is not for us to say whether the decision is right or wrong.
So you, as a counsel in charge, prepare the agenda, recording the case development, recording the costs of the financial matters of the case, and then giving some sort of a recommendation, what to do, to approve or subject to comments. Then it will be discussed within the management of the Secretariat, and then it goes into a court session, which is, as I understand, either a committee consisting of 3 court members, or in significant matters, for example, state entities involved, it would go into the plenary. And what does the court members in charge for this case then do? Do they give further comments, because it's a court decision at the end?
Remember I said in the beginning, court members are practitioners, so they know how it works in practice. They act as arbitrators, they act as counsel, so they also know what problems may occur with enforceability of the award. So they come in, they may say that some of the comments are unnecessary, so as a result of the court's intervention, some comments may be taken away, and they may have additional comments they raise. So, so there's a discussion. I said something wrong. Alexi is leaving.
Alexi, did we do something? Alexi, anything wrong?
Did we say something wrong? That you're leaving?
Oof.
Au revoir. So.
And this is what I wanted to document, because I'm sharing a lot of court sessions where we scrutinize awards. It's a very time-consuming and resource-intense process over many, many layers. But I think the idea behind it is that it serves as a sort of a guarantee that an award is finally enforceable.
To the extent that we can do it, of course.
To the extent that you can do it. So do you really also look at the jurisdictions, place of arbitration, place of enforcement?
Yes, well, to the extent that we can. I mentioned that teams in charge of the case are regional, you know, have a team per region. So for instance, I manage Central and Eastern Europe. So obviously I've read a number of awards from the region, and I expect that certain things may be more important in Romania or Poland than in other countries. So we try to follow on the developments on the, you know, if there are set-aside proceedings and we are informed about it, we try to read judgments of state courts to see what is taken into account. but also in terms of applicable law. If I have an award under Polish law, under Romanian law, and if there is an issue of, I don't know, prescription of claims or statutory interest, and I don't understand, I will ask my intern to go and do some research. So we do try to have a regional look, local look on cases.
And is it proper to ask you for your expertise? So if I had obtained an award and it needs to be enforced, for example, in Romania, would it be proper to pick up the phone and say, it's my first enforcement case in Romania, can you recommend local counsel? How does it work, or how far would your services go?
I would definitely not recommend. I think we have to have a strict neutrality, so I would definitely not recommend a local counsel. I think it will be inappropriate for me to do this.
Yeah, thank you, Maria. And I hope you have now an even better idea than before about how ICC proceedings work in practice inside the ICC headquarter buildings in Paris. It's a wonderful building. I learned that also the people from the Secretariat are very approachable. So if court members are from Helsinki and are at the ICC in Paris, the Secretariat members are very open to say hello and show you around. So I can only invite you to have a very close and personal look at the persons who are dealing with these matters, because at the end it's a people's business also on this level, and it really helps to get to know each other and put a face to what has been written. So this was the interview from our side. If there are any questions, please let us know. Thank you.